Supplementary list, item number 1.
May I please, your lordship. My lord, the appellant is convicted RI for life for offence under section 376 D IPC and 120B of IPC and fine of rupees 2 lakhs and 1 year for 66 of IT Act and 3 years of 67 of B of the IT Act. My lord. That is running page 44.
Yes.
My lord, 6 months in each court offence under section 323/506 IPC, my lord. And the appellant is custody, my lord, since 2010-2014, my lord. And last occasion on dated 6/5/2024, my lord was directed to the custody certificate of the appellant.
Yes, Mr. Patia.
Munawara. Munawara. That's right. My lord, in this case, my lord, occurrence was held on 22/7/2014, my lord. 22/7/2014 occurrence, my lord. An affair was lodged on 18/10/2014.
Two 783 days. Munawara has undergone a period of 2783 days.
I just calculate it divided by 365. How many years?
7 years,
8 months.
8 months.
Yes, my lord. Out of 9 years, some months, my lord, he is on parole, my lord. That some period he is on parole due to he is surrendered.
That is to be excluded. So,
Yes, my lord.
So 7 years is there. And when the conviction.
And sentences for remainder part of the life.
Because it's a case of gang rape, so that is why.
My lord, the appellant absolutely direct, no direct allegation against rape.
Identified in the TI
yes,
period.
My identified in TI period, and the appellant role is that, my lord, he is co-told the friend of the victim girl.
Whatever it may be, it's a.
And 2 other person was taken to the victim 100 to 150 meters. Thereafter, one by one rape, and some mobile photograph was taken. My
next, we also wanted instruction about the criminal antecedent and about the creation of law and order problem as per the order dated 6/5/24.
Item 2.
May I please, Your Lordship? I am representing Mr. C.R.Sahoo. Your Lordship, the appellant is convicted under 302-201 of IPC and sentenced to undergo imprisonment for life and pay a fine of 5,000 each. In ID to payment, each shall suffer RI for a period of 2 years.
What is the custody date?
Your Lordship, the custody date is 19/9/2014.
You have never been released on bail during trial or by
No.
this court on interim bail.
No, Your Lordship.
So sentence is 302 life imprisonment.
Yes, Your Lordship.
What is the name of the deceased?
Baisi Munda.
Kono?
Baisi.
Boyce na Boyce? Boyce Munda. Okay. Date of occurrence?
Occurrence is, Your Lordship, 9/9/2014.
Any eyewitness to the occurrence?
Your Lordship, PW8, son of the deceased.
PW8, son of the deceased. So two accused persons face trial and
One on bail, Sunna Munda. The co-accused was on bail.
On bail means granted by this court?
Granted by this honorable court.
In which criminal appeal or jail cell?
So, this was the order. Copy.
Pass on.
Those 10/2/2020.
এই case re?
Order.
Son of Munda. But Mr. Katkia, the reason which has been given while allowing the bail application of the appellant number 2, that no specific overt act has been attributed against him. But if we see the evidence of PW8, his evidence is that both of them assaulted by stone.
Yes,
What he has stated in the
cross means my father was assaulted by stone by accused Lakhan Munda. That was just stated.
My father was killed once after killing my father. Stone. Okay. In the chief, he has stated by both. In the cross examination, he was stated only one.
Yes.
And what about the doctor who conducted PM examination?
Lordship, PW14.
Cause of death is due to hemorrhage and shock arising out of
There is some injury on the head, right frontal bone, and fracture of maxilla. So that is there. Who is in custody about 9 years and so on. part, the learned counsel for the petitioner, learned counsel for the state, learned counsel for the appellant. Number one, Lakshan Munda submitted that the petitioner is in judicial custody since 19/9/2014. And as per the evidence of the son of the deceased, Munda? Boisi Munda, who has been examined as PW8, both the appellants assaulted the deceased by means of a stone. And the appellant number 2, what was the order? 10 February 2020. The appellant number 2, Sanapula Munda, who is similarly situated, has been released on bail by this court. I had order dated 10/2/2020 in IA number 132 of 2019. And in view of the period of detention of the petitioner in judicial custody, the bail application of the petitioner may be favorably considered. This is an application for bail by appellant number 1. The learned counsel for the state, on the other hand, that though PW8 stated in his examination in chief that both the appellants assaulted the deceased by means of stone, but in the cross-examination, he has stated that the deceased was assaulted by the present petitioner, and that was the reason for which the appellant number 2 was granted bail. Considering the submission made by the learned counsel for the learned counsel further submits that the doctor PW14 who conducted post-mortem examination over the dead body has noticed number of injuries on different parts of the body, including the head, and opined the cause of death due to hemorrhage and shock arising out of the injury to vital organ like brain. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced during trial, while not inclining to release the petitioner on bail on merit but taking into account his period of detention in judicial custody, and keeping in view the ratio laid down in the case of Letty versus Swan, so we are inclined to release the petitioner on bail, interim bail, for a period of 3 months. The learned counsel for the state shall obtain report from the Swans IAC. Yes. What is your good name? Please give it in a slip. Mention her name.
Item 3.
Usual order would be there that you will file the surrender certificate for 3 months. Yes.
On criminal cases, we have filed interim application and matters of kind of to direct the state to take instruction regarding the offense discussion also. And legal certificate which has been annexed with the
Whose element it is? Whose element?
judgment.
Element.
So
Wife of the petition.
so
We are holding CRLA number 231 of 2022.
there, the wife element I have great cost.
So what instruction you have received, Mrs. Sahoo?
Minor.
What is the conviction here?
Like
No.
02.
302. How many years you are in custody?
That I am in custody. 2008, more than 8 years. Date of occurrence is 13/2/2016. After that,
IA number so and so. This is an
I
application.
am for the information.
Ah.
Your Lordship may allow, I have no objection.
Yes.
But since the dispute arises due to political reason and election is on 25th, for that your Lordship may allow release the appellant after 25. See,
Why are you depriving him to cast the vote?
he will not cast once a convicted melody is debarred from voting.
Convicted, depart from voting.
Yes, sir.
Who said that? A person convicted.
Once a convicted, he is barred from voting. Under trial, my lord, he has the right to vote. But once a convicted, a person cannot.
So was the provision that he has no right. In the RP Act, it is there that if somebody is sentenced to 2 years or more, then he cannot contest. So where is the provision?
I know, my lord.
No, I know means that is not. What you know, that's a different matter. You have to substantiate it. Or the learned counsel for the petitioner, learned counsel for the state. It is an application for interim bail on the ground of ailment of the wife of the petitioner. And the matter was taken off on 17/5/2024. And copy of the interim application with medical documents was supplied to the learned counsel for the state. He sought for time to obtain instruction on the interim application. Today, the learned counsel for the state has produced the data dated 19/5/2024 of IIC Saranpur Police Station, wherein it is mentioned that the petitioner's wife is suffering from acute pain and medical documents are genuine, and there is no other male person available to look after the wife of the petitioner, and she is having minor son and minor daughter in the house apart from his wife. The learned counsel for the informant opposed the prayer for bail, interim bail, considering the submission made by the learned counsel for the respective parties, the grounds taken in the interim application, the medical documents annexed thereto, the instruction received by the learned counsel for the state, we are inclined to release the petitioner on interim bail. What your wife is?
What is the nature of illness?
What you have
the
stated?
doctor has said that for proper treatment in the higher medical center. So that's why some within time.
For a period of 2 months, and during interim bail period, he shall not indulge in any criminal activities, or shall not try to come in contact with the members of the deceased family. The family members of the deceased. Violation of any terms and conditions shall entail cancellation of bail.
Urgent certificate in court.
Urgent certificate.
In both of them.
So this IA number so and so, and he to file the surrender certificate.
Under criminal appeal 178 of 22. In that appeal, interim application was filed for range for 3 months. Appeal 178 of 2020.
Yes.
Now, or your lordship had directed the jail authority to furnish a certificate with regard to health condition of the petition.
Acha, you are praying for interim bail on
Interim bail.
your health condition.
Yes, sir.
So what instruction you have received from the jail superintendent?
Set back.
This man is Supadev Rao
Supadev Rao.
Supadev Naik and disease. And it status report of Supadev Manapolis. This is for Supadev. Eta. So eta uchi Supadev Rao 9. Supadev. Status report of Supadev. ଗୋଟେ କପି ଦେଇଥିଲେ ଗୋଟେ ଅଲଗା ଅଲଗା cardiology medication currently is having এটা Rakita, এটা Supadev Rasovita Plata. This is who is appearing in this case, CRLA number 2. Ajay, you are Mr. Sahoo, you are appearing. CRLA number 178 of 2022. This is IA number 881 of 2022. This is an application for interim bail on the health ground of the petitioner. As for order dated 17/5/2024, the Land and Council for the state was asked to obtain instruction through Jail Superintendent Noyagar about the health condition of the petitioner. Today, the Land Council for the state has produced the report from Superintendent District Jail Noyagar, wherein it is mentioned that the petitioner is suffering from coronary artery diseases, hypertension, diabetes, and he was undergoing treatment. Is undergoing treatment in Department of Cardiology, SCB Medical College, Qatar, since March 2023, taking medicines, and is having increase in shortness of breath, so on. So chest pain, etc. Land Council for the informant opposed the prayer for bail. Considering the submission made by the Land Council for the respective parties, governments taken in the interim applications, report furnished by the Land Council for the state, we are inclined to release the petitioner on interim bail for a period of 2 months. Same condition, he shall not class a previous order. And he has to file the surrender certificate. Yes. Next.
Item 4.
No, item 3, sub-item 215, 225, and 177.
Nobody is moving, so
Arjun, my lord.
just
My lord.
this item number 4.
You also matter kind enough to call for a report.
No, you have filed one application for extension of interim bail. Please look at the list. Are you on interim bail?
Last time I was granted Chenmar Nutram. I filed IA for a fresh interim bail, my lord. And it was on earlier when my lord has kind enough to grant interim bail, and for the purpose of extension it was filed. Last time also I filed.
Okay, acha. That had already been disposed of. It has inadvertently come in the list. Likhi diyantu. IA number 890 of 2023. even though this interim application has been disposed of being infructuous as per order dated 17/5/2024, it has been listed again. Registry shall not list this interim application henceforth. Stop. Yes, you have filed an application for interim bail on what ground?
I know 1244 of London.
On who ground?
Illness of wife.
So yes, you are supposed to obtain instruction on that. Feeling pain in the abdomen, treated at district headquarters hospital, Kota. Medical documents, genuine. Father-in-law, mother-in-law. Science. कितने वर्ष रह गए नहीं?
10 वर्ष.
Right. IN number 1244 of 2024. This is an application for interim bail on the ground of ailment of the wife of the petitioner. Instruction was sought for as per order dated 17/5/2024 on this interim application. Today, the Land Council for the state has produced a report from the IIC Nirakarpur police station, wherein it is mentioned that the wife of the petitioner is suffering from pain in the abdomen, and the medical documents annexed to the interim application are genuine, and is having his parents in the house apart from two minor sons. The report furnished by the Land Council for the state is taken on record. Considering the submission made by the Land Council for the respective parties, the governments taken in the interim application, report furnished by the Land Council for the state, we are inclined to release the petitioner on interim bail for a period of 1 month from the date of release. While on interim bail, it's a case under section 302. Shall not try to come in contact with the deceased family members of the deceased, and shall not indulge in any criminal activities, violation of any terms and conditions, until cancellation of interim bail.
376 I also there. 376 also.
Okay, 1 month we are granting bail on this health grounds. Okay. And he has to produce the surrender certificate if he's declared.
Pardon, Lordship. Lordship, in item 4, kindly delete the name of Mr. B.S. Daspada and Associates.
Is a sole appellant here? Item number 4A, Santosh Kumar Pillai.
Yes, my learned senior, Mr. Chandula.
Sole appellant, my lord. 508 of 2022.
Sole appellant. Mention is made on behalf of Mr. B.S. Daspareda that his name, so also the name of his associates, cannot be reflected in the cause list as the brief has already been transferred. In view of such submission, the names of Mr. B.S. Daspareda and his associates shall not be reflected in the cause list. Yes.
Item 5.
May I please issue Lordship?
May I please your lordship, my lord?
Yes.
Here two appeals, my lord. In so far as first appeal is concerned, 875, my lord. One appellant is there, who is on bail, my lord, in the at the time of trial, my lord.
No, you are moving which application?
Both,
Which
my lord.
appeal?
Both.
Both. So let us go to the second one first. The CRLA number 988 of 23. What is the conviction here?
Life, my lord.
For the offense under section
326, 302, 34 IPC.
302. So what is the delay?
My lord, 299, my lord. Perhaps I think, my lord,
Delay
order
condone.
dated 2/11/2023 se already condoned the delay.
Delay condone.
Delay condone.
Then why it has come? देखिए order sheet तो किसी 988 of 2023. Who order है ये?
2/11/2023
31/8/2023 एटा काई ये करना सिलेक्शन नहीं जोड़ा नहीं ताको स्कैनिंग करी है ना IA number so and so this is an application for condonation of delay. It appears that on 31/8/2023 delay has already been condoned and interim application has been disposed of, right? Now admit is na nahi
Admit is stay realization is.
and the criminal appeal has already been admitted and stay of realization of fine has been granted. The registry shall not list this interim application further. Stop. Yes, in this application, have you filed any bail application?
Yes, sir.
Second
both
one.
both the
So what is the IA number? Second. CRLA number 988A. What is your application for bail? Acha 2124.
2122.
2124 of 2023 is an application for bail. कोटा तुम कौन कहलु देखिए ऑर्डर हमें तुम कौन कहलु देयर इज ए order has been passed. The stamp reporter has pointed out that there is delay of 299 days in filing this criminal appeal after hearing the learned counsel for both the parties, and since it's an appeal against conviction in which life imprisonment has been awarded for the offense under section 302/34 IPC, we are inclined to condone the delay in filing the criminal appeal. Accordingly, delay is condoned, IA is disposed of, hard admit, call for the trial court record.
988 your pass question order.
Yeah.
Is there any order in 22/9/2023 madam?
No
22/9/2023 order ଅଛି
9
88 CRLA.
there is no order at all.
condone the delay.
It is coming no order at
Because in our file also it has been mentioned.
no. Today it will be the first order number 1. So he gave a wrong impression to us. That is why. So in this call for the LCR, it appears that the LCR trial court record has already been received in the connected CRLA number 875 of 2023. Yes, now you can argue your bail application. You want to argue the bail application in both
First, yes,
first. So
far as first appeal, criminal appeal is concerned, my lord, appellant is
Kulabari.
Pulabari, my lord.
Kulabari, okay.
My lord, during trial, my lord, he is on bail. Only 4 months, 21 days he was in custody, my lord. Thereafter, from the date of judgment till date, my lord, 1 year, 8 months, 13 days. Total, my lord, 2 years, 1 month, 4 days till date.
Hmm.
And so far as the second appeal is concerned, there are 2 appellants, my lord.
Second appeal means CRLA
988. 2 appellants,
Hmm.
namely, my lord, Sachida alias Premalu Barik and Minoketan Barik.
Yes.
They are, my lord, they till the incident, my lord, they are custody, my lord, 9 years, 2 months, 8 days.
No. Both of them were not released on bail
No.
during trial. So when they were taken into custody?
My lord, 13/2/2015, my lord.
13 to 2015.
15.
They have never been released on bail.
Yes, sir.
Achha. So what is the name of the deceased?
Name of deceased, my lord, Premraj Karan.
Huh?
Premraj Karan, 70 years old.
Premraj Karan.
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 RAN.
Date of occurrence?
Date of occurrence, my lord, 12/2/2015.
12/2/2015. So eyewitnesses are there?
Yes, your lordship.
Who are the eyewitnesses?
As per prosecution case, my lord, there are 5 eyewitnesses, my lord. In fact, 1 eyewitness are there.
No. Who has been examined in the trial court
Eyewitness,
as an
my lord,
eyewitness?
PW 5, 3, 8, 13, 16.
PW 3, PW
5,
yes,
8, 13,
yes,
and 16.
So let us come to one eyewitness.
My lord, if your lordship look into the evidence of PW 8, who is the daughter of the
You want to
deceased,
place the evidence of PW 8.
8, your lordship. Thereafter, your lordship
And
come to conclusion that
20 is the injured.
yes, your lordship,
20.
he has not seen the entire incident. After assault, my lord, he fled away from the spot. That is
No, he was present at the scene of occurrence.
first
Received
time.
the injury.
Initial time, my lord.
He has seen one part of the
One part. So,
but this PW 8 has seen
entire scenario. He's
Right.
the she is
Let us come to that PW 8 then. So what she has stated? PW 8 is the daughter of the deceased.
deceased and sister of the injured and a sister of the informant, my lord.
Okay. At that time, all the accused persons went there, started quarreling with us as to why we destroyed their straw stacked in the said cultivable land. At that time, accused Sachida Barik. So, Sachida
In Sierra Leone.
Barik is 988. Sachida Barik armed with axe and Minoketan. Minoketan is appellant number 2.
Your lordship.
Holding a body and accused Kula means this appellant. Holding a weight. All the accused persons abused my father and Ekadasya and assaulted both of them. During the said occurrence, Sachida dealt a blow to the right cheek of Ekadasya by the axe.
Ekadashi is period 20.
Resulting profuse bleeding injury. Acha. On being injured, Ekadasya left the said cultivable land. The accused persons also assaulted Premraj, my father. This is the deceased.
Yes,
So,
lord.
accused Kuna dealt a blow to the left leg of my father by Kula mane ki?
Appellant, my lord, in first appeal.
Acha, faster. Kula dealt a blow on the left leg of my father, resulting fracture. Accused Sachida assaulted by axe. Minoketan dealt blow by means of head with a club. Then so on so. So everybody participated. So who is the PM doctor?
So far, my lord, there is one major discrepancy between inquest report and postmortem report with regard to injury inflicted upon the deceased, my lord.
Let us come to
In
first the
inquest
PM
report,
report.
yes, your lordship.
PM report के doctor की
My lord, PW 12, your lordship.
PW 12. Let us come to that. So 70 years old man and lacerated wound on the left ankle, lacerated wound on the right knee, so right knee, so and so leg fracture, skull bone fracture, occipital region, time since death, cause of death is due to head injury. So,
But inquest, there is no such injury at all in the head, Miller.
might not have noticed that the doctor conducted the PM examination, noticed the fracture of skull bone and extradural hemorrhage is there, and opined the cause of death due to coma due to head injury. And this PW8 has stated specifically as to that accused Mino Ketana dealt blow by means of a club on the head of my father. But this Kula assaulted by on the left leg and Sachida just assaulted by axe.
Right ankle, Miller. Of the
Who
leg.
goes right ankle?
Yes, Lord. Evidence is there, Miller.
Mino Ketana, club and head.
Left.
ଗୁଲା ଯିଏଟା କମ ମାସ ରହିଛି ସିଏ ଲେଫ୍ଟ ଲେଗ କୁ ମାରଲା ଯୋଉଥିରେ ଇଞ୍ଜୁରି ଅଛି yes Mr. What is Acha, are you sure that they are in custody for 9 years and let us see that final form?
Your Lordship, come to the judgment, first page, Your Lordship, running page.
Acha, first page lekha hai.
23, Your Lordship.
Let us see that. We are this
Column
Sachida-
A1,
Sachida and Minoketan. Minoketan ala 13 to 2015 till date when 2022 acha.
That is
So eta hochi kete hobo apankor
9 years, 2 months, 8 days, till date.
9 years, right? 9 years and 2 months.
8 days.
And this
A2 accused 2 Miller, Premalu alias Sachida Barik also
Sachida
same.
to Ditto mane same. Okay.
Same.
So 9 years, 2 months.
Yes. Then accused number 3.
He was on bail.
On bail, that is.
He was in like CRL number 875 of 2023. Kulawari. IA number so and so. This is an application for bail. The London Council for the petitioner submitted that the petitioner was on bail during trial and he has not misutilized his liberty after the pronouncement of the judgment. He has been taken into judicial custody. It is further argued that as per the evidence of the eyewitness Rebati Karan, bracket PW8, who is the daughter of the deceased Premraj Karan, the petitioner assaulted the deceased on his left leg by a quid, K-U-E-D. And the doctor who conducted, Dr. bracket PW12, who conducted post-mortem examination over the PW kete
12 Your Lordship.
PW12. who conducted post-mortem examination over the dead body of the deceased, opined that the cause of death was due to coma on account of the head injury. And he noticed a lacerated wound on the left ankle, so also on the right knee. And since the blow given by the petitioner is not the cause of death, the bail application of the petitioner may be favorably considered. Learned counsel for the state opposed the prayer for bail and submitted that apart from PW8, PW3, PW5, PW13, PW16, and the injured PW20 have also stated to have seen the occurrence. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during trial against the petitioner, fact that he was on bail and the land counsel for the state has while on bail, absence of any chance of early hearing of the appeal in the near future, we are inclined to release the petitioner on bail. This is Kulavari, bail granted. This IA number 3032 of 2023. What is this application IA? Flag E?
Preponing file after long adjournment it was
Okay,
filed.
it's not pressed for them. IA number 3032. Now you come to the set of Harkaro, you have 9988. That is IA number 988 रे मैं आगुरु order pass करथलो जो admit करिया तादेर तापे एटा लिखिबे IA number 2123 of 2023 sterilization of fine allowed. Then 2124 of 2023 there is an application for bail. The land counsel for the petitioners submitted that the petitioners were taken into judicial custody
13/2/2015
on 13/2/2015
Yes.
and they were never released on bail during trial, and as such they have completed more than 9 years in judicial custody, and there is no chance of early hearing of the appeal, and therefore the bail application may be favorably considered. Land counsel for the state, on the other hand, opposed the prayer for bail and submitted that as per the evidence of the eyewitnesses and the role played by the petitioners, they are the main assailants, keeping in view the findings of the doctor who conducted postmortem, Dr. Bracket and the P.W. Swan. Considering the submission made by the London Council for the respective parties in view of the nature of evidence adduced against the petitioners during trial, while not inclining to release the petitioners on bail on merit, but keeping in view the ratio let down in case of Letty Swanson and period of detention in judicial custody, we are inclined to release them on interim bail for a period of 3 months. Report about the.
May I submit one thing, my lord?
And he has to file the surrender certificate after that. Yes, next case.
Oblige, your lordship.
Item 6.
Item number 6.
May I plead my
No, I for interim bail, my lord. Last of the report was called for me regarding health condition of the wife of the
Interim bail IN number 775/24.
my lord.
So have you obtained instruction, Mr. Das? The wife's ailment has been taken as a ground for interim bail.
No.
The wife's health condition is normal, and the doctor advised you go to for the higher center for further investigation. He has not, she has not gone, and health condition is normal. Of course, OPD ticket and medical certificate are found to be genuine. So, why bail will be granted on health condition? May move the other bail application, there is no problem. But health condition is the everything is normal, why bail will be granted on?
As per medical documents.
No, you can move the bail application on merit, there is no, but so far as this IA is concerned,
No.
IA number 775 of 2024, there is an application for interim bail on the ground of ailment of the wife of the petitioner. As per the order dated 15/5/2024, the Learned Council for the state has produced report from the inspector in charge of Chandaka Police Station, Bhubaneswar, UPD, wherein it is mentioned that though the medical documents are genuine, but the doctor advised the petitioner for further investigation in higher center, but she has not gone for such further investigation, and now her health condition is normal. In view of such report furnished by the Learned Council for the state, we are not inclined to grant interim bail to the petitioner. Accordingly, IA number 775 of 2024 stands dismissed. Do you want to move the other application?
The application, my lord, inside custody 12/5/2016, my lord.
Just a minute. So, what is the custody date you said?
My lord, 12/5/2016.
And you have been convicted under section
302. Life, man.
302 life imprisonment. Your bail application has never been rejected earlier by this court.
Earlier petition was granted interim bail, my lord.
Interim bail.
Period of IA number 2896 of 23.
By order dated?
Order dated 2012/2023.
Okay. That is death of the father of the
man.
All right. So, what is the name of the deceased?
Priyadarshini.
Priyadarshini Panda.
Priyadarshini. And eyewitnesses are there?
PW2, my lord.
PW2.
Mother of the deceased man.
PW2, mother of the deceased. But she has stated, I and the deceased were in the house. My husband and our son had gone to Hatta. Deceased Priyadarshini was then stitching something, and 8-month-old son was in our house. Sometime later, Priyadarshini took the child to the house of Anjana. 22, and I heard the cries of Priyadarshini coming out from our courtyard. I ran outside, saw the accused holding Priyadarshini, closing her mouth by the left hand. He was stabbing Priyadarshini on her chest by means of knife. And I shouted, the accused fled away in motorcycle. So, stab injury on the chest by knife. Who is the doctor?
PW9, ma'am.
PW9 PM Dr. Tikasi. Incised wound on the center of the neck, thyroid cartilage directed one. So, oh, how many blows you have given? And all the injuries are on the vital part of the body. 1, 2, 3, these are all incised wounds. Penetrating wounds are also there. Abdomen, neck, everywhere you have assaulted. 11 stab wounds you have caused on the. Sorry.
May payment. So it may be urgent to after vacation.
IA number one. So this is an application for bail and counsel for the petitioner seeks for an adjournment for this matter in the month of July. Date they will.
Obliged.
Yes, about the Monday. Weekly list, anything is there? You are of Kaitla. That is not clear with it. See, pass over that.
Weekly list passover item number 6.
On appears screen after vacation date, they were 24 June 2024.
Item 8.
May I please, Lordship?
Yeah.
Yesterday, Lordship directed the London State Council to take instruction with regard to
You are moving a CRL number 465 of
465 of 2014.
It is that Lord's Hotel case.
Yes, ma'am.
I verified the C of the petitioner. This is so and so. Found except this case is involved in Tanky case number so and so. Case has also been charge sheeted on the section. During the interim bail period, so and so, nothing adverse was found. So, what is the custody period?
Yes, my lord. Present appellant was all along on bail during course of trial by remaining inside custody for 1 year and 6 months, my lord.
In this appeal, there is only one appellant.
There are two appellants. Present appeal is one appellant.
Right, Popu alias Kishore.
Yeah, right, ma'am.
So,
and after conviction, my lord, he was taken into custody, my lord. On date of pronouncement of judgment, thereafter he remained inside custody 9 years and 10 months, and he was released on interval 5 times, 5 occasions, my lord.
By this court?
By this court, my lord. That number is 142 days, my lord.
Last time you are released on bail On
interim bail, that is on 27/7/2018. Your Lordship has also indicated that by virtue of order dated 13/5/2024.
ଆଗରୁ ଯୋଉ ବେଲ୍ ଯାଇଥିଲା କେତେ ମାସକୁ ଯାଇଥିଲେ 142
142 days. First,
ସେ ଟାଇମ୍ ଟୁ ଟାଇମ୍ ଦିଆଯାଇଛି ନା
from, he was initially released on interim bail on 13/5/2024, 21/9/2015. Thereafter,
as per the order dated 13/5, this is item number CRLA number 465 of 2014. ଗୋଟେ ମିସକେସ୍ ଅଛି for free of realization of fine ସେଟାକୁ allow କରିଦେବେ ହେଲା ବାକି ଯୋଉ IA number ଅଛି so and so ସେଇଥିରୁ ଲେଖନ୍ତୁ the Learning Council for the as per the order dated 13/5/2024 that is আচ্ছা এটা হচ্ছে 100 নম্বরটা বলবো actually IU number 2014 of
2022.
2014 of 2020. This is an application for bail as per the order dated 13/5/2024. The Learning Council for the state has obtained the report from the IAC Purighat police station wherein it is indicated that the petitioner has got one criminal antecedent and during the interim bail period just given for 5 times. Nothing adverse was reported against him. Learned counsel for the petitioner submitted that the petitioner, after remaining for 1 year in judicial custody, was granted bail during pendency of the trial, and after pronouncement of the judgment, he was taken into judicial custody. Pronouncing the judgment on 23/7/2017, and he has remained in total period more than 9 years. Considering the submission made by the Land Council for the respective parties, the nature of evidence available on record against the petitioner, while not inclining to release the petitioner on bail on merit, but taking into account the period of detention in judicial custody, and that fact that 5 times he has been released on interim bail and nothing adverse has been reported against him, we are inclined to release him interim bail for a period of 2 months from the date of release. While on interim bail, he shall not indulge in any criminal activities or try to come in contact with the family members of the deceased. Violation of any terms and conditions or entail cancellation of bail. And you have to fix a date, he is to produce the surrender certificate. This is taken on record.
Lord, with my Lord's permission, can I submit one line? Who appellants released on 3 months bail?
No, you are the main person who threw the bomb.
No, according to the evidence of the P1, my Lord, but I am not here to analyze the evidence.
Let us see your conduct this time. We'll see.
Obliged.
Yes.
Item 11.
Item 11. Hmm. What is the date of custody? 27/4 2012. You are never released on bail to. So it is more than 12 years, sir. What is the name of the deceased? Huh? देखिए.
Lost by the father of the deceased. Even the petitioner is son-in-law.
Eyewitnesses are there.
No evidence.
Then what are the materials against?
Matters like that. The evidence of the video of the father.
Hello. And in the FIR lost by the father, the PW1, examiner PW1, and the mother of the deceased, the PW4, and doctor.
What the parents have stated?
Parents said that the petitioner was assaulted her daughter, suspecting the character. That is not mentioned the FIR. The same thing as I told.
Mr. Counsel, if the parents have stated that you have assaulted
Assault by
deceased,
pressing of help to throat, my lord.
whatever it may be, and then how do you say that there is no eyewitness to the occurrence?
No, I don't. Even at the time of occurrence, he was at another place, my lord. He heard the news that her daughter was the petitioner has killed her, and pressing
the
of throat.
evidence of PW.
PW1, my lord. I'm reading PW1.
How you are related to that deceased?
The father, my lord.
No, the appellant.
The husband, my lord.
So, marriage between the accused and my daughter Saria.
Saria, my lord. Was performed about 7 months back to her death. The marriage was performed in accordance with the occurrence and custom. 2 to 3 months after the marriage, accused ill-treated her by assaulting as she could not tolerate the torture of accused. I had brought her to my house and kept her in my house for about 2.5 months. On day after about 2.5 months, which is 4 to 5 days prior to her death, the accused and his father came to my house and asked me to send Saria to their house. Accordingly, I agree with them. Then my brother-in-law, Sola Niranjan Nahaka, took my daughter with him and left her the house of accused. After 4 to 5 days, my daughter was left in the house of accused while I had been to the house of my another daughter, namely Malati. I got information that my daughter Saria is serious. Getting such information, immediately myself and my wife rushed to the house of the accused and found my daughter Saria lying dead in the house of the accused. When I opened the...
He was with you when she died,
Right.
and the doctor is PW. PM doctor is PW.
Six, my lord.
6.
Doctor, my lord. The cross-examination, my lord.
You see how many injuries she has sustained and the cause of death, that thyroid cartilage was fractured, and the opinion has been given that the nature of death is homicidal and cause of death was on account of asphyxia resulting the compression to the neck and chest.
Yeah.
So he sustained homicidal death while staying in your company within 7 months of marriage.
The doctor in the my lord, the opinion that the changes described above and the external injuries noted are the antemortem nature and consistent with the asphyxia mode of death. The
How
cause
do you explain when she was in your company, how she died? And
is not explained, my lord.
huh?
The only allegation that the deceased were dead, the occurrence held in the house of the accused.
We are asking you a question under section 106 of the Evidence Act.
My lord.
Your wife, who is the deceased in this case, was in your company. She died a homicidal death. You were strangulated to death.
My lord.
Then you are to explain under what circumstance she died, who
And
caused
that,
her death.
the question is the motive, my lord. The para 9 of the husband, my lord.
And evidence of the parents are there that you were torturing the deceased for which she came and
I'm
stayed with
para
the
9, my
parents.
lord. Sorry, my lord. Para 13 of the judgment, my lord. The thus from the prosecution evidence, the following incriminating circumstances were found conclusively established that the relation between the accused and the deceased was a husband and wife. The accused had motive to kill the deceased. The nature of that is said is homicidal. The point number 8, my lord. This was healthy both physically and mentally when she was left in the house. My humble submission, my lord. When the mentally and physical wealth, my lord, they cannot say that there is torture, long-time torture, my lord.
Long standing torture କଣ ଆପଣ ତ ବାହାଘର ପରେ ଯେତେବେଳେ ଟର୍ଚର ହେଲା ବାପା ମା କହୁଛନ୍ତି ସେ ଆସିକି
The reason, my lord, the reason are mentioned. The FIR at the cross examination told that they're suspecting the character. Another thing is somebody and the mother said that at the time of occurrence he or husband are not present, but the Niranjana Mahako, the Naik was present, but he has not been examined.
This period which you are telling, that is correct. This period of detention.
Detention, my lord, 27.
Trial court record you have. Final
27 for 2021. 2021, my lord.
You have never been released on bail.
Well, my lord.
Are the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case on 28/4/2012.
27, my
27 arrest or
Arrest
case
him, my
reproduce
lord.
and as such he has remained in custody for more than 12 years. The case is based on circumstantial evidence and the motive behind the commission of crime has not been established and there are good chances of success. Balance of convictions is favor of the petitioner. And since there is no chance of early hearing of the appeal in the near future, this is item number
11, my lord.
and paper book has not been prepared. The bail application may be favorably considered. Learned counsel for the state, on the other hand, opposed the prayer for bail and submitted that the petitioner is the husband of the deceased Saria and the deceased was staying in the company of the petitioner at the time of her death and the doctor bracketed PW6 who conducted post-mortem examination has noticed number of injuries on the person of the deceased and opined that cause of death was due to asphyxia resulting from compression of the chest and neck, and it is homicidal in nature. Learned counsel further submitted placing the evidence of PW1, the father of the deceased, was stated that the appellant was torturing the deceased physically and mentally during 7 months of the marriage. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced during trial, particularly the report of the doctor, bracketed PW6, while not inclining to release the petitioner on bail on merit, but taking into account his detention period for more than 12 years and absence of any chance of early hearing, keeping in view the ratio laid down by this court in case of Letty versus Swanson. 3 months bail granted, he has to call for a report from this source.
Well, then noting this, that without consent, I have taken file Bhinama, I have engaged with the High Court legal aid matter.
You have been engaged.
My lord.
All right. Since Mr. Radharaman, Radharaman Das Naik has been engaged by the High Court Legal Aid Committee to be counsel for the appellant. The name of Ms. Aditi Kota shall not be reflected in the cause list henceforth. Hello? Yes. It.
Item 12.
12, Mr. Jatindra Mohan Raut. Oh, there. None appears after, that is 24th June 2020.
Item 13.
Item 13, same counsel. Jatindra Mohan Rao. Not in. Same order. 24/6/2020. Yes.
Item 19.
19, Mr. Mahapatra.
Yes, my lord. My lord, this is a case under section 302, 34, along with 323.
Why to today?
My lord, instructions have been sought for.
Obtained regarding the custody certificate, my lord. As per the petitioner submitted that the petitioner is in custody 13 years, but in fact the petitioner is in custody 4 years, my lord.
My lord, I'm coming to it, my lord. P9.
1,540 days, my lord.
Yes.
In respect of
My lord,
two,
my humble submission, P9 kindly be seen, my lord.
No.
Para 2.
Let us first go one by one.
Yes,
you made a submission.
Yes, 13 years.
13 years. That
Yes,
is not.
that is that I'm coming to the point.
Coming to the point. Adir ଆଉ point କଣ ଆସିବାର ଅଛି?
Sir, ଆପଣ para 2 ଟା ଦେଖନ୍ତୁ sir P9 ରେ. On 13/6/2000, I arrested Ekus Sankulia Naik and seized one bamboo stick from his house by preparing a seizure list in presence of witnesses. This is the said seizure list marked as Exhibit 4/2 and Exhibit 4/3 is by signature thereon. On the same day, I arrested Guru Nahako. Then on 13/6/2000, kindly noted. Then, my lord, lower court.
କେବେ କହୁଛି arrest କଲା ବୋଲି?
13/6/2000.
ନିଆ ହେଇଛି ତ?
Yes.
ତାପରେ ଆପଣ ବେଲ ରେ ଗଲେ 20/4/2001 ରେ। ସେଟା ଆପଣ କ୍ଲାଏଣ୍ଟ ଆପଣଙ୍କୁ କହିନି।
Sir, ମୁଁ ଗୋଟେ 5/11/2008.
ଆପଣ ଯୋଉ ବେଲ ରେ ଯାଇଛନ୍ତି?
My lord, yes, my lord. Lower court record, trial court order may kindly be seen, my lord. 5/11/2008, my lord.
5/11/2008. 20/4/2001 ଲେଖା ହେଇଛି release date ବୋଲି. And then again you
5/11/2008 kindly be noted. Order may be seen, my lord. Lower court order.
ଦେଖିଲେ 20/4/2001. Bail bonds accepted and directed to be released from bail. How who date को then?
5/11/2008, my lord.
The record is put up today on the strength of advance petition filed by the council fund. He also files the certified copy of the sworn show of the Honorable Court in BLAPL number and pays to release the said accused on bail. Sworn show. custody of the appears. এটা কাহার আনিছেন কি?
Guru Nahak, my lord. Appellant number 2.
Guru Nahak, please come to the second page. You have mentioned the release date is 20/4/2001, but okay, accused were absent. Acha. ଆପଣ ବେଲରେ ଥିଲେ 20/4/2001 ବେଲରେ ଯାଇଛନ୍ତି, ତାପରେ ଷ୍ଟେପ୍ ନିଆ ହେଲାନି ଆପଣଙ୍କ ତରଫରୁ, ସେଥିପାଇଁ NBW ଇସ୍ୟୁ ହେଲା। NBW ଇସ୍ୟୁ ହେଲା ପରେ then you were produced on 13/11/2007.
Sir.
Then you applied for bail and this court granted you bail.
Yes, ma'am.
Because it's a Belgium matter, then you were released on bail on that day which you are pointing out.
Then I beg pardon to return.
So that's not correct what you are making a submission. The total period has been calculated and it is 1540. A plus B plus C. So 1540 means it is 4 years.
But you're 2 months, 20 days. Mein.
I want to withdraw my application. I want to withdraw.
What do you want to withdraw?
The bail application.
IA number so and so 24 on this an application for bail as per order dated so and so. The Land and Council for the order dated at the 7/5/2024. The Land and Council for the state has produced the custody certificate. So submission was made that the petitioner number 2, Guru Nahak, is in judicial custody for 13 years. But on perusal of custody certificate, it is found that he is in custody for 4 years and 2 months. The custody certificate is taken on record. Land Council for the petitioner does not want to praise this application. Accordingly, the IA disposed of as not praised.
Item 20.
May I see the petition?
Yes.
The appellant challenges the order dated 27/9/2019 and convicted under section 302 IPC, and he is in custody 18/1/2014, your lordships.
18/1/2014.
14, your lordships. And 6 weeks
Offense under 302.
302
Life
your-
imprisonment.
life is your lordships. And 6 witnesses have already been examined, and exhibit and PW5 is the
What is the name of the deceased? Let us know.
His name is Dolly Pingua.
Dolly
Dolly
Pingua.
Pingua.
Date of occurrence?
Date of occurrence is 17/1/2014.
Eyewitnesses are there.
One eyewitness is there.
Who is he?
PW5 is
PW5 is the eyewitness.
Subhas Borij.
What he has stated?
Your lordships.
I and the mason are staying in there at the relevant time. We heard after some time deceased Dolly came inside the room with bleeding injuries on her. Then she came out. We also came out. The accused again assaulted Dolly by means of tangia. Acha. On her neck and escapes also. So why this appellant assaulted a lady? What
Is the 17/1/2014.
What is the relationship between the appellant and the deceased?
Each and every day, he is the son-in-law of the deceased, your lordships.
Okay.
Son-in-law. Each and every day, he came to the house of the deceased and demanded for money for to take a drink for liquor, your lordships.
Okay.
On the said date, he came to her house and demanded the money and quarrel with and where the wife Gurubari also staying in the house of the deceased, your lordships. And
Okay, so you dealt axe blow on your mother-in-law, right?
mother-in-law.
So PW4 is the doctor who conducted postmortem examination
Yes.
and noticed deep cut injury
In right on
of
her
the
right
right
side.
angle of mandible, and a date is due to hemorrhage and shock, and weapon of offense was also produced, and he gave his report. So you are not released on bail during trial?
No, your lordship, no. He's been arrested in 18/1/2014 and no interim bail. Till today, he's in custody, your lordship.
And during this pendency of this criminal appeal, you have never also been released on interim bail, etc.?
No, your lordship.
So it is more than 10 years.
10 years, 3 months, your lordship.
Are the Learned Counsel for the petitioner, Learned Counsel for the state? The Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 18/1/2014. And the deceased, Dolly Pingua, was the mother-in-law of the appellant. And the prosecution case is that during course of quarrel, the petitioner assaulted the deceased by means of tangia. And in view of the period of detention in judicial custody, and since there is no chance of early hearing of the appeal as paperwork has not been prepared, the bail application may be favorably considered. Learned Counsel for the state opposed the prayer for bail and placed the evidence of PW5 Subhas Barij, who is an eyewitness to the occurrence. So also the evidence of PW4, the doctor who conducted post-mortem examination, noticed deep cut wound on the right angle of mandible and opined the cause of death due to hemorrhage and neurogenic shock. Considering the submission made by the Learned Counsel for the respective parties, nature of evidence adduced during trial, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention in judicial custody for more than 10 years and absence of chance for early hearing of the appeal in the near future, and keeping in view the ratio laid down in the case of Leti versus Swanshaw, bail is allowed or interim bail is granted for 3 months. But he report called for a, and he has to file the surrender certificate. Yes. That's all.